Good afternoon and welcome. My name is Kathleen Roberts. I'm co-founder and co-director of Partners in Justice International and a member of the steering committee of the Women in International Law Interest Group of the American Society for International Law, or WILIG. WILIG was created to promote and enhance the careers of women in the field of international law. WILIG not only supports those who identify as women who are already in the field to allow the development of their full potential for achievement and leadership, but also supports, encourages, and enhances opportunities for others who are interested in entering the field of international law, including through an extensive mentoring network. WILIG also works to promote awareness of gender in all areas of international law. If you're not already a member of WILIG, we hope you will consider joining us. On behalf of WILIG, it is my pleasure to welcome you to this webinar addressing the newly launched prosecution policy on slavery crimes at the International Criminal Court. In this, the first public discussion since its launch on the International Day of the Abolition of Slavery last week, we will examine the promise and potential impact of the new slavery crimes policy. I also want to thank the co-sponsors of this event, ASIL's International Criminal Law Interest Group, ICLIC, and my own organization, Partners in Justice International, PJI. Now, I'm just going to share a link to the policy itself in the chat. Let's see, and I share it to everyone. There we go. All right. The new International Criminal Court policy on slavery crimes presents slavery as one of the oldest and most persistent atrocity crimes, universally reviled, yet continuing both in war and in peacetime. The policy acknowledges that historic institutions of slavery were constructed and maintained through interplays of racial discrimination and asserted racial superiority, religion, ethnocentrism, commerce and empire, traditions and customs, military forays, and patriarchal norms, as well as raw political prowess. It asserts that the effects of these institutions have been deeply rooted, running through generations, and have been and continue to be extremely difficult to dismantle. The policy presents slavery crimes as a set of atrocities that hide in plain sight, cloaked in misconceptions that derive from these same roots of the effects of violence that maintained historic institutions of slavery. According to the policy, it is necessary to acknowledge this reality with self-awareness and emotional intelligence, to recognize power and privilege, and to overcome barriers to work and success. While in principle, all agree that this crime should be prosecuted and eradicated, to seek accountability for it requires the ability to hear past the noise of the self-regard instilled by privilege, or, as the policy puts it, to confront these issues with a measure of introspection, humility, and urgency. The policy offers not only legal specifications, such as distinguishing enslavement from other crimes and violations, for example, human trafficking, forced labor, or servile status, and noting the shortcomings of the Rome Statute itself, which codifies enslavement as a crime against humanity, but not as a war crime, and which does not yet codify the crime of slave trading. The policy also offers guiding principles as well as specific steps for implementing the policy at each stage of the investigation and litigation process. This is a remarkable set of commitments by the Office of the Prosecutor and a hopeful roadmap for practitioners outside the court. Many of us hope that this first ever commitment of an international judicial institution to a formal policy specifically addressing slavery crimes will guide justice actors in taking a survivor-centered, trauma-informed, and gender-competent approach to these crimes, increasing the effectiveness of their investigation and prosecution, and thereby providing greater opportunities for justice for more victims. Now, I'm delighted to introduce you to several experts who can shed some light on this important new policy. First, I want to personally thank Patricia Viseur Sellers, without whom we could not have brought this webinar together. Patty is an international lawyer and a special advisor for slavery crimes to the prosecutor of the International Criminal Court. She teaches international criminal law on the master's program of the law faculty of the University of Oxford, where she is also a fellow at the Bonnevero Human Rights Institute. She previously was the special advisor on gender to the former prosecutor of the International Criminal Court, Mrs. Fatou Bensouda. She was the legal advisor for gender, acting head of the legal advisory section, and an acting senior trial attorney at the UN International Criminal Tribunal for the former Yugoslavia, and the legal advisor for gender at the UN International Criminal Tribunal for Rwanda. She advised and developed the legal strategy for the case, the prosecutor versus Kunarach, the leading case on enslavement as a crime against humanity from the Yugoslav Tribunal. She's authored numerous articles concerning slavery crimes under international law, including Missing in Action, the International Crime of the Slave Trade, Wartime Female Slavery, Enslavement, Sexual Slavery, and Customary International Law, and The International Crimes of Slavery and the Slave Trade, a Feminist Critique. Ms. Sellers is the recipient of the prestigious Prominent Women in International Law Award and the Goler T. Butcher Award by the American Society of International Law. She holds an honorary doctorate in law from the City University of New York, as well as an honorary fellow for lifetime achievement from the Law School of the University of Pennsylvania, her alma mater. Valerie Oosterveld is professor and chair in international criminal justice at Western University. She's the special advisor on crimes against humanity to the ICC Prosecutor. Her research and writing focus on gender issues within international criminal justice, and she's published widely in this field, including on the concept of gender in international criminal law and the interpretation of sexual and gender-based crimes by international criminal courts and tribunals. Her co-edited volume with Indira Rosenthal and Susanna Sakuto, Gender in International Criminal Law, was awarded the 2023 Willig Scholarship Prize for Best Book. Previously, Professor Oosterveld was awarded the 2022 Royal Society of Canada Ursula Franklin Award in Gender Studies, and she was awarded Western University's Faculty Scholar designation from 2017 to 2019. Professor Oosterveld is the acting director of Western University's Center for Transitional Justice and Post-Conflict Reconstruction. She is also a member of the SSHRC-funded Canadian Partnership for International Justice, which was awarded the 2023 Governor General's Innovation Award and the 2022 SSHRC Impact Partnership Award. Hilda Pineda is a criminal lawyer and a former human rights prosecutor. She litigated human rights violations and international crimes for over 10 years in Guatemala, starting as a public prosecutor and eventually becoming head of the Office of the Prosecutor for Crimes Against Human Rights in 2016. In that capacity, she litigated high-impact cases, such as that against General Efrain Rios Montt, in which the former president of Guatemala was sentenced to 80 years in prison, although that sentence was later overturned by the Constitutional Court. She also obtained convictions in the Dos Eres massacre case and the Seprazarco case, the first ever sexual slavery case tried in a national court. She was transferred out of her position while she was overseeing the so-called military diary case, in which 12 retired military personnel were accused of participating in forced disappearances, kidnappings, torture, and summary executions of at least 183 people between 1983 and 1985. Judy Mionki is a Kenyan jurist specializing in international criminal law and human rights. Judy has worked at the International Criminal Court as part of the defense teams in two situations, the situation in Kenya and the situation in the Democratic Republic of the Congo. She has also acted as legal advisor on Ukraine within Amnesty International's Center for International Justice and as legal advisor on fair trial rights with the International Bar Association's International Criminal Law Program. Judy's current work primarily focuses on sexual and gender-based crimes. Her latest article, Children Born of Conflict-Related Sexual Violence as Direct Victims under International Criminal Law, was published by the Journal of International Criminal Justice this past October. She holds a Master of Science in International Human Rights Law from the University of Oxford and a Master of Laws in International Law and International Relations from the University of Kent. I'd like to offer Patty the first question. Patty, why was a policy on slavery crimes developed by the Office of the Prosecutor of the ICC? Why was it necessary?
Well, thank you very much, Kathleen, for the question, but also let me thank ASIL and Willig and the International Criminal Law Group and Partners in Justice for holding this inaugural discussion about the policy. The slavery crimes policy was necessary because under the Rome Statute, which governs the International Criminal Court, it became very obvious in the Office of the Prosecutor that we had not really developed our legal theories, our investigation strategies around the slavery crimes to the extent that was necessary, meaning that they could be used more fully to represent the actual experiences of survivor and victims who were enslaved. Another reason is that we understood that there were times when the slavery crimes, and particularly enslavement as a crime against humanity, was confused with crimes such as trafficking or forced labor. And let me say another reason that we had to look at this, and particularly from my former position as special advisor for gender, is to understand sexual slavery and the nexus of it to enslavement, and to see if in a manner of investigation, we were feminizing sexual slavery, as if that only pertained to women, and masculinizing enslavement, and maybe in between the two, missing the full characterization of slavery acts for enslaved persons, whether they were adults, whether they were children, whether they were males, females, or anywhere across the gender spectrum. So a slavery crimes policy was basically to set our strategies, some of our definitions and our future practices in a clearer light. And hopefully that would inform our partners who exercise complementarity under the Rome Statute.
Thank you. And turning to you, Valerie, what's your impression of the policy and how do you see its impact on the jurisprudence of the court, especially regarding crimes against humanity?
Thanks so much, Kathy. I think that this policy is absolutely groundbreaking for two reasons. First, as has already been mentioned, it's the first such policy at any international tribunal ever to provide comprehensive guidance on how to conceptualize, investigate, charge, and prosecute slavery crimes in a gender and intersectionally sensitive manner. And the prosecutor says in the preface, this policy provides the concepts, principles, and practical considerations surrounding slavery crimes that will inform the office's investigations, submissions before the court, and interactions with survivors. And I think that last part is very, very important. So this is why the policy covers preliminary examination, investigation, confirmation and pretrial, trial, sentencing, appeal, and reparation stages. So it is comprehensive in terms of the International Criminal Court process from beginning to end. Now, of course, this particular guidance is helpful for the International Criminal Court's Office of the Prosecutor, but it's also helpful for investigators, documenters, prosecution services, and courts around the world involved in the consideration of slavery crimes. So for ICC states parties, this is important for complementarity, but for non-states parties and UN investigative bodies, it's also helpful, as well as civil society documenters, I believe. Secondly, here is where I think it brings a value added beyond what might not be immediately obvious. It provides the framework necessary to understand that a charge of enslavement often serves as an explanatory charge. And what do I mean by this? I mean that it explains why many or all of the other charges happened. So whether the other charges are torture, persecution, rape, forced marriage, or enforced disappearance, for example. It's like the umbrella that explains the context of those other crimes that took place. So the policy is important for the linking nature, the explanatory nature that it provides. Modern day slavery in war and in peacetime is often misunderstood, and this policy explains that. And because modern day slavery is often misunderstood, it's not always seen for the sum of its parts. And this explanatory nature helps to bring it together and makes sense to judges. And the policy in doing this surfaces the contours of enslavement in similar ways as other policies, like the 2022 policy on the crime of gender persecution. I should also point out that the policy, if you haven't taken a look at it, for those in the audience, it outlines potential factual indicators in addition to the ones that are already set out in the Rome Statute. So it explains how various forms of violence, force, or control of physical and physiological and psychological autonomy, the use of addictive or reproductive drugs, physical sequestration, forced procreation, forced and child marriage, extortion, and trafficking are all potentially factual indicators and part of the economies of slavery. And lastly, I just wanted to mention that it highlights the temporal nature of enslavement, that it's a continuing crime. It explains how the various treaties that address slavery fit within the Rome Statute crime or help to inform the Rome Statute crime. And it also explains, including with a visual aid, the overlap of enslavement, sexual slavery, trafficking in persons, and the slave trade. Thanks.
Now, Hilda, as Valerie just mentioned, the policy articulates a number of principles to guide slavery crimes prosecutions, including adopting a survivor-centered and trauma-informed approach. You litigated the Sepper-Zarco case, the first sexual slavery case to be tried in a national jurisdiction, and it resulted in conviction of 2 high-level defendants for sexual slavery as a war crime and sexual slavery as a crime against humanity. This case was not only inspiring for the precedent it established, but also for the method by which you approached it, building the case around the testimony of the victims. What is your impression of the policy, and how would these principles relate to your experience of the Sepper-Zarco case?
Sí, agradezco mucho la invitación a poder participar en este foro y realmente veo que la política abarca muchas cuestiones importantes, ¿verdad? Que nosotros pudimos desarrollar dentro del caso Sepur-Sarco, dentro de ellos el tema del testimonio, ¿verdad? Como principal elemento para iniciar una investigación criminal, porque alrededor del testimonio es cómo se van construyendo los otros elementos probatorios y podemos recoger toda la información, ¿verdad? Que las víctimas nos puedan dar acerca de los bienes o de los derechos que les han sido violentados, ¿verdad? Por eso es que en este tipo de hechos, ¿verdad? Tal como se recoge en la política, hay una pluralidad de bienes o derechos que se violentan, ¿verdad? Y no solamente uno en exclusivo. Es por eso la importancia de la contextualización, ¿verdad? Que refiere también, ¿verdad? Poder entender el contexto de la situación, como ocurrió en el caso Sepur Sarco, donde nos encontrábamos en un conflicto armado, ¿verdad? Y todo, cómo las víctimas no tenían a dónde acudir y cómo eran sometidas a todo tipo de vejámenes, ¿verdad? En este caso específico, mujeres violentadas sexualmente, esclavas, ¿verdad? En estos destacamentos militares donde ellas eran abusadas de manera reiterada y colectiva, ¿verdad? Individual y colectivamente. Y además el trabajo forzado al que fueron obligadas, ¿verdad? Como cocinar, lavar ropa a los hombres de esta comunidad. Y también entender la interculturalidad, ¿verdad? O entender cómo las comunidades o los pueblos mayas, en este caso en Guatemala, también tienen sus propias formas de vida, ¿verdad? Su cosmovisión, que eso también crea lesiones, ¿verdad? Dentro de toda la sociedad. En este caso, las comunidades, pues, se rompió el tejido social, ¿verdad? O sea, afecta no solamente a la víctima, sino a una comunidad completa, ¿verdad? Entonces, el testimonio lo que hace es que nos da toda esa información que se recoge muy bien en la política y poder reforzar todo ese testimonio a través de expertos, ¿verdad? Que nos pueden dar otro tipo de información como los análisis psiquiátricos, psicológicos, que nos hacen determinar cuáles son las lesiones que presentan las víctimas, ¿verdad? Lesiones emocionales o mentales que en el caso de Sepur-Sarco son irreparables, ¿verdad? O sea, no hay forma de reparar la lesión que se les causó a ella. Si bien es cierto, dentro del caso se logró la reparación digna. Esta reparación va en favor de la comunidad principalmente en temas de educación, salud y cuestiones que el Estado debería de garantizar, ¿verdad? Sin embargo, es una sentencia quien pide o impone la obligación al Estado de que se cumpla con este tipo de reparaciones. También el tema del contexto, ¿verdad? Que se recoge también en la política y lo pude leer, ¿verdad? Que está los peritajes históricos, culturales, ¿verdad? Los lingüísticos, atendiendo al tema de que las víctimas en el caso de Sepulsarco no hablaban idioma español, ¿verdad? En Guatemala tenemos 22 comunidades lingüísticas, ¿verdad? Entonces, sí es bien complejo el tema de la investigación, entonces por eso es tan importante los peritajes lingüísticos, porque en el caso de Sepulsarco las mujeres no conocían la palabra violación, ¿verdad? Esa palabra no está utilizada dentro de su lenguaje o de su idioma, entonces para ellas pasó sobre mí, ¿verdad? Rompió mi matrimonio, eso significaba la violación a la que habían sido sometidas de manera reiterada y también el contexto que ayuda en el tema del peritaje histórico a saber toda la coerción, ¿verdad? Toda la amenaza, toda la violencia que ellas sufrieron durante este conflicto armado, ¿verdad? Y cómo ellas no podían escapar, ¿verdad? Porque también esto fue una de las cuestiones planteadas durante el juicio. ¿Por qué no se iban, verdad? ¿Por qué regresaban a cumplir un turno? Si ellas podían irse, ¿verdad? Pero en ese contexto ellas no podían escapar, ¿verdad? Porque estaban totalmente en un ambiente coercitivo, ¿verdad? Sin poder salir de ese ciclo de violencia y cómo cambia su rutina al momento de que ellas son cambiadas por mujeres más jóvenes, ¿verdad? Para seguir el turno y son liberadas a raíz de que se esclaviza a otras mujeres. Ese patrón sistemático, ¿verdad? Los patrones que se dan en este tipo de delitos que también lo refiere la política, que es importante determinar en la investigación para poder saber, ¿verdad? Cómo ocurrió en Guatemala, que no fueron hechos aislados, ¿verdad? Sino que fueron hechos sistemáticos, fueron hechos planificados desde el más alto mando del ejército, ¿verdad? Teniendo una política de seguridad nacional, ¿verdad? Y por la lucha, ¿verdad? Que se veía por la desigualdad social que existía en ese momento y que pues aún prevalece, ¿verdad? Únicamente.
Thank you for that. Judy, now all three of the panelists have spoken on themes that resonate and reflect each other in really interesting ways. I want to add in one additional piece and ask you about how the policy articulates a principle of child competent approach and the full and faithful characterization, or as part of the full and faithful characterization of slavery crimes. How do you see these principles and the policy generally in light both of your research and of your experience on the defense team for Bosco Ntaganda, who was convicted at the ICC, among other crimes, for recruitment of child soldiers and sexual slavery?
Thank you, Kathy, and hello, everyone. I joined the legal team of Bosco Ntaganda at the reparations phase, and it was, yes, the first time that the International Criminal Court held that children born out of rape and sexual slavery may qualify as direct victims for the purposes of reparations. And I think anyone who's looked at how international criminal courts and tribunals have viewed reproductive violence in the past can attest to the fact that these children have been viewed mostly as secondary victims, as indirect victims, as evidence of the crimes committed against the mother. So after the Ntaganda decision, we got the ongoing reparations order, where the trial chamber yet again held that children born out of forced marriage, forced pregnancy, rape, and sexual slavery qualify as direct victims for the purposes of reparations. So I'm looking at both decisions and I'm realizing there's so much not being said about these children, because even in Ongwen, where they were much more discussed during the trial, it was mainly in relation to the crimes perpetrated against the mother. So I wanted to find out what are the precise harms suffered by these children, and what is the precise connection between the harms and the crimes for which, both Ntaganda and Ongwen were found guilty. And so my research does this, or attempts to do this. It traces a continuing pattern of criminal conduct perpetrated against these children. And the first we see it is at the ICC in the Connie charging document, where it says that children born to enslaved mothers are considered enslaved themselves. And Valerie has already explained, what other crimes stem from this umbrella crime or this continuing crime. But what it means for us is that we can now pursue accountability and not relegate these children to the reparation stage, which is, of course, incredibly important. But there is another discussion to be had, which is where we capture the full range of diverse harm suffered, the sexual, the reproductive, the psychological. And I think this is what the policy does so well. It doesn't relegate these children to reparations. It emphasizes, this child competent approach and this full and faithful characterization of slavery crimes. It wants the court to capture the full scope of crimes, the full scope of a perpetrator's criminal responsibility, from the initial investigations all the way to reparations, again, as Valerie said. So this is why, for me particularly, I find this particular document, so important, because, crimes will not go under the radar anymore. That, at least that's what we hope, and that specific groups of victims like children are not going to be overlooked. Thank you.
So I'm going to turn now to Patty. As I think a couple of our speakers, I think both Judy and Hilda spoke to this a little bit, and Valerie probably also did. The policy states that there's many misconceptions and biases about contemporary slavery crimes that are actually rooted in historical and cultural ignorance, discrimination, racist, colonial, sexist, ableist, paternalistic, patriarchal, and homophobic misperceptions. What are the most frequent misconceptions of slavery crimes?
Thank you, Kathy. Well, I think, as a matter of fact, Judy just brought up one of the biggest misconceptions, is that we fail to understand that children who are born of enslaved parents or enslaved mothers are usually themselves enslaved persons. And as enslaved persons, they're direct victims. But related to that, another misconception that is very frequent is that, well, what if the person doesn't know they're enslaved? Does that mean that the crime disappears? Well, there does not have to be awareness of your own slavery for you to be enslaved. And I think the perfect example are often young children who might not be able to conceptualize and conceive of their enslavement, but yet someone is perpetrating the powers attaching to the right of ownership, which is the indicia or the evidence of enslavement, as Valerie said. So that's one of the big misconceptions. Another one that's closely related is, well, what if the enslaved person consents to their enslavement? Does that therefore eliminate the harm that they've agreed to be enslaved? And the answer is no. It's very much like torture. You cannot consent to torture. If you consent to torture or to enslavement, it's legally immaterial in terms of the construction of the elements of the case. So you might have people who are ingratiating themselves with their enslaver to survive, and therefore say, yes, I love this person, or let this situation continue. This is how I get food. That does not eliminate and shouldn't turn our focus away from the enslaver who's exercising powers of ownership. So consent is legally immaterial in terms of determining whether the elements of the crime have occurred. And the other misconception that is frequent, alluded to by Valerie and Judy, is this question of time. Well, slavery is a continuing crime. It starts once someone is exercising powers of ownership over you, or even when you're being slave traded, when you're being reduced to enslavement. And it only stops when all of the powers that have been exercised over you halt, cease. So that might be a half a day. It might be a week. And we know in some instances when women are kidnapped for 2 or 3 weeks, i.e. kidnap means slave trading, that the 2 weeks might be the time period of their enslavement. It might be several years. It might be a lifetime that we've seen with enslaved children who are recruited as soldiers, or persons who are in almost hereditary slavery, that the slavery begins upon being born and ends upon death. And that might be a death that's committed by their enslaver. But time is not an element of the crime of slavery. So you don't have to prove how much time you were enslaved. The focus is on whether anyone exercised powers of ownership over you. And one of the other misconceptions, I think, that often allows us not to see enslavement is that we expect that the slave has to do something if they're enslaved, or has to suffer. But the enslaved is not required to do any work, do any hard work or toil. The enslaved are not required to show that they are in anguish or they are suffering. The focus is always on who is exercising powers of ownership. So an enslaved person might be well fed, might be well housed, but the indignity of having someone exercise powers of ownership on you is the focus that we should have in terms of slavery crimes. So just to recapitulate, the enslaved don't have to do anything. As a matter of fact, how the powers could be exercised over them is that they're prevented from doing things, prevented from being with their families, prevented from choosing with whom they might want to be in a relationship or a family. It could be the very omission and not necessarily the commission of what you do. So those are common misperceptions and misconceptions around slavery crimes that I think are very vital to understand, so that the proper investigation and submissions can be made before a court. And also, I think it's important in terms of advocacy for civil society organizations.
Thank you. I think everybody's going to be going to find this list extremely helpful. Just reminding us all that some of these strategies for survival are not actually going to eliminate the crime that's been committed by someone, among other things. So Valerie, let me turn to you. How do you see the relationship of this policy and the draft articles on crimes, the draft articles on Crimes Against Humanity Convention in connection with forced marriage?
Thanks so much, Kathy. So I'll begin by saying that for those who are not following the process, the International Law Commission created a draft convention on crimes against humanity and sent it to the United Nations General Assembly 6th Committee, that's the legal committee, in 2019. And since that time, the 6th Committee has been discussing this draft treaty, and very recently it decided to send that treaty to negotiations. Now, the reason why we raise this today is because the draft Crimes Against Humanity Convention takes the list of acts that are listed in the Crime Against Humanity provision of the Rome Statute and replicates them in the draft Crimes Against Humanity Convention. So that means enslavement as a crime against humanity and sexual slavery as both a crime against humanity and war crime, or sorry, of course it doesn't cover war crimes, but sexual slavery is also listed in the draft Crimes Against Humanity Treaty. Now, I see a couple of aspects of the relationship between this policy and the discussions around that draft Crimes Against Humanity Convention. First of all, the insights gained from this policy will undoubtedly inform the consideration of the enslavement and sexual slavery provisions that are listed in that draft convention. And that draft convention is moving into the negotiation phase over the next 4 years. So there will be discussion provision by provision in those upcoming discussions and negotiations. But also a number of countries have proposed adding the slave trade into that particular treaty alongside enslavement and sexual slavery. And therefore the discussion in the policy of the slave trade and its link to enslavement will help to inform those considerations, I believe. Secondly, because the policy explains how a number of different acts, including the act of forced marriage, which is a deprivation of relational autonomy, can serve as an indicator of enslavement, I do believe that the same sorts of understandings of the links between enslavement and other types of acts will be carried into the draft Crimes Against Humanity Convention discussions as a result of the surfacing that happens in this particular policy. Thanks.
Thank you for that. Hilda, you mentioned earlier you talked about the challenges of a survivor-centered investigation and prosecution where you're dealing with Indigenous communities who didn't speak the majority language in your country. How does the policy reveal or draw lines between historic situations of slavery and vulnerable communities, such as those Indigenous communities in Guatemala and Indigenous women?
Sí, pues leyendo, reflexionaba sobre el tema de cómo la esclavitud puede ser en cualquier contexto, ¿verdad? De los distintos países que existen, ¿verdad? Y que ser esclavo, cualquiera podemos serlo, ¿verdad? O sea, cómo se va modernizando las formas de esclavitud. Entonces, no nos podemos quedar en un tema histórico de decir quiénes fueron esclavos, ¿verdad? O como si esa forma de esclavitud es la que existe actualmente, sino que se va modernizando, cómo se van actualizando las nuevas formas de cometer este crimen, ¿verdad? Este tema de esclavitud, ¿verdad? Y reflexionaba sobre el tema de los matrimonios de menores de edad, la trata de personas, ¿verdad? Que se refería y cómo estos crímenes van siendo, incluso necesitan ya investigaciones transnacionales, ¿verdad? Donde debe haber cooperación de diversos países para poder tener este tipo o recoger todo este tipo de información, ¿verdad? Entonces creo que hay que ser muy creativo, ¿verdad? El fiscal en su investigación tiene que ser muy creativo y tiene que pensar más allá de una forma de esclavizar, ¿verdad? Sino cómo eso se va dando, ¿verdad? Y cómo el trabajo forzado, ¿verdad? En distintos contextos también puede ser una forma de esclavitud, ¿verdad? Por eso es que hay que ser muy cuidadoso y creo que la política lo desarrolla muy bien, ¿verdad? Cómo hay que indagar lo suficiente para poder entender cómo a una persona se le esclaviza de forma moderna, ¿verdad? Eso es lo que concluyo, ¿verdad? Que el fiscal tiene que ser acucioso, ¿verdad? En esos temas. Y principalmente vuelvo a llegar al tema del testimonio de la víctima, ¿verdad? Por eso es tan importante el testimonio, porque ella es la que nos da toda esa información, ¿verdad? El fiscal jamás se debe cansar de escuchar a la víctima, ¿verdad? La debe escuchar y darle el tiempo suficiente para que ella le pueda dar toda esa información necesaria que da las demás líneas de investigación, ¿verdad? Al momento de construir un caso, ¿verdad? Porque es la víctima quien ha sufrido, quien ha llevado todo el proceso, ¿verdad? Y es ella quien nos puede dar toda esa información. Y también no pretender que la víctima nos va a dar toda la información en la primera entrevista, ¿verdad? Eso es un proceso que hay que hacerlo de manera con mucha tranquilidad, con mucha paciencia, ¿verdad? Y también el apoyo psicológico que necesita la víctima en ese proceso, ¿verdad? Porque son temas que a ellas les afectan y que hay traumas, ¿verdad? Que están tratando de superar, ¿verdad? Entonces, teniendo todos estos elementos, podemos descubrir que la esclavitud se actualiza, ¿verdad? En nuestra sociedad y que es necesaria la investigación y pues castigar este tipo de crimen, ¿verdad? Porque no se puede tolerar ni permitir que siga ocurriendo únicamente.
Thank you. And that's a good reminder about the importance of witness evidence. But Judy, let me turn to you now and ask, you work with open source evidence. Do you see slavery crimes benefiting from evidence gathered from open sources in addition to witness evidence?
Yes, I mean, that's the short answer. We know there's already work being done on how open source evidence can, aid in investigations relating to conflict-related sexual violence. We've seen this in action, for instance, in Sri Lanka, where the OHCHR considered incredibly gruesome photos and videos of dead detainees as amounting to outrages on personal dignity. We have also seen in the past the ICTY, the International Criminal Tribunal for the former Yugoslavia, rely on videos and photos and satellite imagery as evidence. So, of course, all this open source information can contain evidence relating to slavery crimes. I think it's just a matter of knowing where to look and what to look for. So, for instance, we've seen videos online of ISIS fighters joking about, the potential purchase prices of Yazidi women. We know that ISIS auctioned Yazidi women and children online with photos and purchase prices and things like this. So that's yet another piece of evidence that demonstrates, the powers over the enslaved person. And I can think of so many other types of open source evidence that you can rely on. So ads on social media, for instance, content created in dating sites. This might all suggest, slavery crimes. And I think there's an incredible wealth of data online, because I think people forget that things like UN reports, civil society reports, all of these are considered open source information. And it's publicly available information, and it can be relied on. And this, I think, is yet another thing that the policy does incredibly well. It identifies, multiple sources of evidence, including open source evidence that can go ahead and prove, slavery crimes. So yes, thank you.
Thank you for that. I think we have a little bit of time for questions from the audience. And I think the first one I'll take probably is best answered by you, Patty. How much of this policy is a codification of jurisprudence, and how much is a creation of new principles?
That's a very good question. I think there's been quite a bit of jurisprudence that has been codified, and one can look back to Special Court for Sierra Leone, which really showed us that child soldiers were enslaved persons, child soldiers under war crimes, enslaved persons under crimes against humanity. I think we can look back to Kunarats at the Yugoslav Tribunal and codify the sexualized nature of enslavement, and particularly when looking at customary law. And we see the same thing with the Habre case that came out of the Extraordinary African Chambers. But coming to the International Criminal Court, that there have been convictions for sexual slavery, as mentioned before, in Ntaganda, but also within the Ongwen case, and convictions for enslavement as a crime against humanity. And we can see the evidence that was built into that were sometimes adults who were porters or had to do some type of physical labor. And also the prosecutor placed the abduction and kidnapping under an exercise of power of ownership. So this policy really brings out that there are innumerable ways or indicators that show that this exercise of power of ownership is being used. So in that sense, the codification of everything that went before the prior jurisprudence, but it also opens up the door to trying understanding other ways that powers of ownership could be exercised, such as, and up until now, we haven't had a case on that, persons who have been forcibly disappeared. And I think about the situation in Guatemala, the situation in Syria. Is there a time period when persons who are forcibly disappeared are also simultaneously enslaved, having someone exercise powers of ownership over them? So that also might be a new way in which investigators can look at evidence, and submissions could be made before the court. So it kind of stands on both codification, but also looking toward future evidence.
Very exciting. Yes. So we have another question. I think, Valerie, I'll direct this one to you. Do you consider the possible prohibition of slavery crimes as crimes against humanity in the new treaty could establish, or what would be their relationship to, universal jurisdiction for, in particular, non-state parties to the ICC?
Thanks, Kathy. So I think one of the benefits of this draft Crimes Against Humanity Convention, if it could get through the negotiation process and become adopted and then implemented by states, could be that it would be adopted and implemented by states that are not currently parties to the Rome Statute of the International Criminal Court. So there are 124 states parties to the Rome Statute, soon to be 125 as Ukraine becomes a state party on January the 1st. But that also leaves a number of countries that are not already states parties. The Draft Crimes Against Humanity Convention is meant to be a treaty like the Genocide Convention, like the Geneva Conventions, that hopefully will become very widely ratified like both of those. And for those countries that allow for universal jurisdiction, the domestic implementation of the Draft Crimes Against Humanity Convention into domestic law could then lead to more prosecutions at the domestic level under universal jurisdiction or other types of jurisdiction that are set out in domestic criminal law. And overall, I think that would be a positive step towards more elimination of impunity.
Thank you. I think we can maybe have one more question, and I think I'll offer this. I don't want to, we only have a few minutes, so maybe a quick response. Let's see. Oh, sorry, too many choices. Proposals have been made to amend the Rome Statute to include enslavement as a war crime and slave trade as a crime against humanity and a war crime. What difference would these amendments add to the ICC's prosecution of slavery crimes? Patty, I'm going to direct that question to you, but if anybody else wanted to speak to it,
thank you, Kathy. I'll say very quickly, the fact that there are no provisions for slavery and the slave trade under the War Crimes Article, Article 8 of the Rome Statute, seems to be an omission. It's a bit unconscionable because the International Commission of the Red Cross, Committee of the Red Cross, for years has said that slavery and slave trade are customary war crimes. And so for them, for the court not to have access. So you might have someone who is sexually enslaved, but that person became sexually enslaved because somehow they were slave traded into that situation. But you really can't fully characterize the slave trade that person underwent. And sometimes you see those gaps in the jurisprudence, such as the jurisprudence of Intiganda. The judges pointed that out, that they could not characterize that conduct as illicit because there was no provision that pertained to it. So I think it would make a vital difference to to enslaved persons.
Thank you for that. I want to thank all of our panelists for their unique and brilliant contributions. I also want to alert everyone who's attending this webinar, if you don't know already, that there's a proposed resolution that will come before the ACIL General Assembly at the annual meeting next April. The resolution concerns recognizing the status of slavery and the slave trade under international law as an international crime, a violation of the laws and customs of war, and a non-derogable human rights violation. This resolution requires a 2/3 vote of the General Assembly and reads as follows. I'm going to read the whole thing because it's very short, okay? Number 1, slave trade is a violation of a non-derogable human right and can constitute an international crime, including a crime against humanity and a war crime. 2, slavery is a violation of a non-derogable human right and can constitute an international crime, including a crime against humanity and a war crime. And 3, the prohibitions of slavery and slave trade are peremptory norms from which no derogation is permissible. Protection from slavery and slave trade is an obligation erga omnes. I would urge all members to attend the annual meeting and vote in favor of the resolution. This is a historic opportunity to participate in reparations as well, since ACIL excluded people of color until the 1960s. So this is a long time in coming. And thank you so much for attending.